the submitted island planning strategy for the Isle of Wight. Can I just check, can everybody hear me okay? Yep, good. Thank you. Can I please ask people to, again, ensure that mobile phones are switched off or on their silent settings, please? I think everybody, or most people in the room, have attended previous sessions, but again, just to briefly reintroduce ourselves, we are Andrew Steen, who's sitting to my left, and I'm David Spencer, and we are the two inspectors appointed by the Secretary of State to carry out the independent examination of the submitted island planning strategy. And it is our role to look at issues of soundness, plan soundness, and legal compliance, including the matters that have been raised through the various representations made at Regulation 19 back in July, August of 2024. And we've got various sessions, obviously last week and through this week as well, based around issues, matters, issues and questions that we've identified from reading the written material that was provided on plan submission. Just to remind you, if you've got any queries or questions around the plan examination process or need to find documents, etc., then your first port of call is Louise St. John Howe, the Programme Officer, sitting at the back of the room to my right, and Louise will help you find any documents, material, or answer general questions that you have around the examination process. Just to remind everybody that these examination hearings are public events available for people to come and observe, but only those who are seated around the table can participate in the discussions, alongside obviously the council's representatives as well. These sessions are intended to be relatively informal but participatory. But any contributions that you make must relate back to your original representations that you made in July, August of last year. Now is not the time to introduce wholly new areas that you've not previously commented on. Can I ask for the council at this stage, are we due any fire test or anything today, please, Mr. Brewer? Thank you.
Good morning, sirs, and thank you. No, there's no planned fire alarm, so if the alarm does sound, if everyone please evacuate calmly through the doors and down the stairs into the car park, and we'll direct you from there. Thank you.
Thank you. Thank you for that. We'll be due to have a mid-morning break this morning, probably around about 11:15, that sort of time. So we'll be doing that. And then this session this morning is due to finish prior to lunch by 1 o'clock, and then we've got a further session this afternoon. These events are being live streamed, and I think as agreed last week with the council, then they are also simultaneously being recorded. Does anybody else for this morning's session also wish to make their own recordings? No? Thank you. Are there any further brief questions at this stage around how these hearing sessions work in terms of process? No. Thank you. Well, for this morning's session, we're picking up the balance of matter 6 around proposed housing sites. This is in follow-up to last week. We had discussions around the general approach to site selection, and then we had time on the Thursday to start looking at the sites in Newport. So this morning's session is looking at other locations where proposed sites are being made for housing within the submitted plan. For the purposes of those who may be following the live stream or the recordings, it would be helpful if people can just kind of briefly introduce themselves as we go around the table in terms of who we're likely to hear from this morning. So we can start with the council's team. To my left first, please.
Thank you, sir. Good morning. My name is Michael Bedford at King's Council, and I'm providing legal support to the council's team.
Good morning, James Brewer. I'm the Planning Policy Manager at the Isle of Wight Council.
Good morning, sirs. Morning, everyone. My name's Ollie Bolter. I'm Strategic Manager for Planning and Infrastructure Delivery at Isle of Wight Council.
Thank you, sir. I'm a Planning and Development Consultant at BCM Wilson Hill. representing various clients.
Phil Salmon of Phil Salmon Planning, representing various landowners.
Thank you, sir. David Farrell, Farrell Design Studios, representing Smallbrook.
Good morning, sirs. It's Lindsay Goodyear from Belcorma, representing Smallbrook Developments.
Thank you. And I think most people who are around the table, I think everybody around the table who's participating this morning has attended previous sessions, so you'll be aware of the format. We'll have various questions for the council. You may wish to come in on relevant points that relate to your representations. One way to catch our attention and to bring you in is to name your nameplates accordingly. Thank you. That concludes my introductory remarks. So I'll now pass over to my colleague, Mr. Steen. Thank you.
Thank you. Yep, may I also say good morning to everyone. Right, this morning, as Mr. Spencer said, we're looking at the housing allocations that we didn't discuss last week, and I've distributed an agenda. Now, the one thing I noticed when I was preparing is that that agenda follows a different route through the sites than I did on the, or we did on the MIQs. So it might take me a minute to find stuff, never mind everyone else. But hopefully you'll bear with us as we do that. But I'm just going to go through the sites. So the first to start with, we'll start with the West Medina regeneration area. And the first site I've listed on that is Somerton Reservoir in Cowes. Now, I understand that there was a planning application on that site that the council, I think you suggested, was waiting signing of a section 106. And there was a suggestion that it might be signed last month. Did that happen? Is there any other update you want to make on that?
Thank you, sir. And it didn't quite happen, but I believe the 106 is now in a position of agreement, and it should be signed and the permission issued in the very, very foreseeable future. And I'm not sure whether Mr. Long potentially would like to add to that, but as far as we're aware from the council's perspective, we're in a position of agreement now, so that permission should be issued extremely soon.
Okay, presumably you'll update us if that happens before we submit anything to you.
Yes, absolutely. Yeah, as soon as that permission is issued, then we'll provide that update through the programme officer. Yeah.
Okay, thank you. I did have a couple of questions on it, which perhaps will become irrelevant, but I'm going to ask them anyway. First of all, there's a question. First question is, you've got a policy on gaps to woodland, saying that there needs to be at least 50 metres, and it looked like that might be affected on this site. Do you want to respond to that query?
Yeah, I think the short answer is obviously the site is adjacent to the Northwood Cemetery, and the sink designation on that land, and part of that further south is woodland. However, I think probably the inspector's report, the planning officer's report, when that site went to committee, set out that matter in detail. So from our perspective as plan makers, when we're looking at the proposed allocations, then we're comfortable that that site sits comfortably alongside those designations to the east and to the southeast of the site.
Okay, I should say I'm going to raise that and similar queries a couple of times probably, and we are going to have a discussion this afternoon on those relevant policies. So perhaps I'll leave any further questions on that until then. But that discussion might link in with what we're discussing here as well. But I'll leave that for now.
I think it's right just to observe the 50-metre policy restriction relates to ancient woodland rather than necessarily all nature conservation constraints. And I think it depends which layer you're looking at on the policies map. There is a layer for the sink, which effectively includes the whole of the cemetery, but then there's a separate layer, I think, for ancient woodland, which is a smaller, as it were, subset within that. And well, you'll be able to see the relationship when you, as I say, interrogate the policies map.
Yeah, I'll have another look at that if I need to, but I think that probably deals with that particular question for now. And there was another query that I picked up about the impact of loss of a reservoir on water security. Do you want to just comment on that?
I think the easiest thing to cover that off is obviously the site is surplus. It's being put forward for development. So in terms of a piece of infrastructure, it's not used. And I think that's the simplest way of answering that question. The site is coming forward for alternative uses.
So it's not currently used as a reservoir, and
No.
no, okay. Okay, thank you. That was everything I had on that particular site. So then the second site is Somerton Farm in Cowes. Same as my first question, really. You suggested the Section 106 legal agreement might be signed in February. Perhaps an update. Thank you.
Risk of repeating myself, I think it's a similar situation where I think we're very close or at agreement on that 106. Obviously, we are just finalising an issue that came out of the representations from BAE, which we touched on last week in terms of the radar. And so I'm happy to go into that issue if you want me to now or wait for a question on it.
Sorry, I forgot to turn my microphone on. Yes, it's included within the Environment Agency Statement of Common Ground, but it wasn't quite clear what the impact of that is on this site.
Yeah, from a flood risk perspective, this was one of the sites which we created a site summary sheet for. So obviously that's been agreed with the Environment Agency and there's no flood risk issues associated with the site. Obviously we have the BAE issue around the employment site, which is just over the other side of the road, and the potential radar issue, which we are just finalising a kind of a condition as part of that planning application. So we're in conversation with the planning agent, the landowner and BAE as well to make sure an appropriately worded condition can be added to the permission to cover off that particular issue. And I think our suggestion would be, if that's what the inspectors consider appropriate, would be that once that condition wording is agreed, which is likely to be within the next week or so, then that could be added in as a site-specific requirement for this site. In the relevant appendix in the IPS, and again we'd be happy to forward that condition on once it's been agreed through the programme officer.
I mean, it sounds to me like if that's agreed and you issue the permission, which you seem to be indicating might be in the next week or two, does that actually mean that it should be within that, stay within Appendix 3, isn't it? Or should it move into Appendix 2 and then you wouldn't have any site specific requirements, so you wouldn't need to do that update? You'd only need to do that update effectively if you haven't signed the Section 106 and agreed the condition.
I think I'm thinking the approach we've taken on a number of other sites as well. There are some sites with planning permission which have site-specific requirements in Appendix 3. Obviously, that it may well be that those permissions expire, and if those permissions expire, then we want those site-specific requirements to endure through the plan period. So we would seek to include that in any site-specific requirements should, for whatever reason, the permission that we're soon to grant on that site would expire.
And it's fair to say it would also cover the possibility, which again does happen from time to time, that the permission might still be extant, but either the developer or indeed a second subsequent developer comes forward with a revised scheme and wants to make a fresh planning application, and therefore, again, the site-specific requirements being in the appendix provide the appropriate guidance, even though if they obviously implement the planning permission that they've already got, they're not subject to the policy test because obviously they've got a planning permission. But if they get any kind of subsequent one or seek a subsequent one, we've got a policy framework to address the relevant issues.
Okay, thank you. That's helpful. Yeah, the other issue that I picked up is that you've updated the yield. I think it went up by relatively small number of units, and that might affect other things like your trajectory and things. I've got that question on other sites, so maybe if you answer it now, I won't need to ask it again. So perhaps you'd just like to say how you're going to deal with that.
Yeah, certainly for the Somerton Farm site, there was a typographical error in the plan, so it should have been an allocation for 160 units. So we've just proposed a modification to Appendix 3 to reflect that, and that reflects the application that is in front of the local planning authority at the moment. I think we covered that off in our response to MIQ 6.21.
I'd pick that up, and perhaps it's less important for this one because it's a relatively small number of units, but there's another one that I'll come back to later where there's quite a high number of units. But does that mean, so perhaps it doesn't really matter for this, but it might do for others. Does it mean you need to update anything else like the trajectory or any other details in the plan?
Yeah, sorry, my apologies there. I didn't answer the trajectory point. So I should have said, so the updated trajectory that we provided as part of our Matter 7 hearing statement, so that covers off this adjustment as well. So the numbers within that trajectory reflect all of the changes that we've made or proposing to make through some of these typographical errors and through the plan.
While we're at this point, I'm afraid I'm going to skip to another site, but it's the Medina Yard site. I'll ask some more detailed questions later, but have you taken that into account in what you put in your Matter 7 statement? Because I think that possibly came out of the EA's Statement of Common Ground, which was submitted slightly later.
Yeah, that's correct. So the Medina Yard site was at the time of submission of the plan, it had planning permission. However, that permission is now expired. There's been a change in land ownership and a potential change in direction. So there's no certainty over that site coming forward in the form that we originally envisaged. So that site does not appear in our updated housing trajectory. So that's come out completely in the trajectory that we had in appended to Matter 7 hearing statement.
Okay, thank you. Yeah, I might still need to come back to that and ask a question, but thank you, that was helpful. So I think that was everything I had on Somerton Farm. Except Mr. Long wants to say something. Yep.
Thank you, sir. I've only got a few points to make. We've BCM Wilson Hill made some representations for the landowner on the 19th of August. I appreciate we'll get onto some environment policies, and I also appreciate that you're not here to look at emission sites as you scoped out. But I think the environment policy, when we relate that back to our discussions re G2 and H1 last week, I put just there is land availability there, but just in relation to the BAE advocating the conditionality that the council is undertaking, that is more than achievable to see the allocation come forward. I'm acting for the landowner. There is another planning agent involved with the kind of the interrelationship with the planning application itself, but positive discussions are happening to resolve and give the certainty that the allocation can come forward quite positively.
Do you want to comment on any of that, or that? I think it was consistent with what you've said anyway, but
Yeah, nothing further to add on those sites.
Sorry, I'm going to try and keep reasonably quiet, but I can't. On the summer, well, both the sites we discussed in relation to the BAE systems, because obviously they made reasonably detailed submissions at regulation 19. Can the council, Mr. Long, give us a kind of an indication around how this issue may be addressed? Because obviously they're concerned about the particular activities they undertake there, and weren't clear from their representations in terms of what they're seeking is whether it's some kind of cordon sanitaire, so there isn't development within a certain distance of their operation, or whether it's going to be an issue, well, you can't build above a certain height to ensure that, or have matters moved on that actually both of those kind of solutions might not be the way forward. It might be something else that hasn't struck us immediately. Appreciate the council is going to update us in due course once there's agreement on that approach, but I don't know if there's anything you could illuminate us on at this stage, Mr. Brewer.
No, absolutely, and we've also been seeking a bit more clarity from BAE on the precision of their obviously representations, which wasn't 100% clear at the time they were made. So we now have that through them. So they have suggested a condition that relates to height above sea level. So that's their primary concern. So they've put a 55 metre height above sea level. Anything below that they're comfortable with. Anything above that may need further assessment as to the impact it may or may not have on their operation. And I think that's the key point there. It's not a blanket below 55 is okay, above 55 is not. It's anything above 55 they'd need to do a bit more work and assessment on the precise location and height. And I think, as we mentioned last week, the land does fall away towards the River Medina, so it's not all of the site that's going to be picked up by this as the land falls away. And again, given the stage of the planning process we're at in terms of the outline stage, albeit with an indicative layout, as Mr. Long quite correctly said, that condition is something that can be comfortably worked with through the scheme, and that's the position that we're seeking to take.
okay, thank you. That's helpful. Yeah, so then we'll move on. The next site, I think, is 84 land rear of 84 Wight Lane in Northwood. Yeah, this is another one where we come back to the 50 metres, because the woodland, ancient woodland in this case, seems to go directly up to the site. And obviously we're going to come back to that this afternoon, so I don't necessarily want you to sort of answer this by and end up having to repeat yourselves. But in terms of the I think your response to our MIQ was that you suggested that it would still be capable of taking the 20 houses, but it may be that they have to be moved into a certain part of the site and perhaps be flatted rather than houses. The other question is whether it looked to me like the access would need to go through within 50 metres, but I wasn't quite clear how that worked or whether it mattered and how that fitted in with the policy. Do you want to say any more on that site with particular focus to that particular issue?
Yeah, thank you, sir. And yeah, as our response to 6.22 set out, there is still, with that buffer, developable land to the northeast of the site. Obviously, the access point comes in off Wight's Lane. And again, from a kind of planning layout perspective, the purpose of that buffer would be to keep that area clear from development. So we feel there is a route through to be able to still develop that site in that northeast corner appropriately. And I say we'll come on to the specific buffer issue itself later this afternoon, I suspect.
Yeah, but on this site, I think the point about the access, is that within 50 metres, or is the concern that it's built development of houses and flats but you're not so worried about the access.
I think the primary concern is that built development, and obviously when you're looking at the other supporting parts of a development site, whether that's through landscaping, verges, areas of open space, etc., and sometimes they can form appropriate features within that buffer, because in some ways they help to guarantee that buffer stays clear of development, and that's the approach we would look to take on that site.
Okay. Thank you. We're going to come back to that anyway later, so I think we'll leave that there. So that was the only question I had about that site. So then we've got the red funnel site. The next one on the list. Yeah, and that's another question about updating where the planning application on that site is, because I think there was an indication. I can't remember whether it was this one. You seem to suggest that quite a few might be determined in February. I can't remember whether that included this one. So thank you.
Thank you. So I don't think I was quite as bullish on this one as I was on the previous ones in our statement, but the latest situation on this application is that we are looking to working towards taking it to planning committee either in March or April this year. So that's the latest on that in terms of the application status. I think as set out in our response to 6.27, we are proposing a modification just to adjust the yield from that site to marry up with what forms the planning application, both in terms of number of units and also employment or commercial floor space. Just for your benefit, as this site has been subject to previous planning permissions that have expired for a slightly different mix of uses. So the developers or the owners of the site Red Funnel have spent some time working on an alternative scheme, and that's the scheme that's before the LPA at the moment. So we're making sure that the proposed allocation matches up with the application that we've got in front of us. Thank you.
So you're sort of implying that you're expecting that to be recommended for approval, but you didn't actually say that. Is that?
It wouldn't be for me to prejudge our case officer's position on that site, but I would imagine, and if I'm speaking out of turn, then I'm sure my line manager to my left will kick me under the virtual table. But I'd imagine that the case wouldn't be going to planning committee unless we're in that realms of trying to make a positive recommendation. So that's where I'll leave that one, but wouldn't want to prejudge anything that could possibly occur through that process.
Okay, thank you. In which case we'll move on to the land rear of Harry Cheat Gardens in Northwood. Yeah, another one with a planning application. So perhaps I can just have an update on that.
And again, I was slightly over bullish in the hearing statement response on this one by saying February 2025. But speaking to the case officer yesterday, the lease agreement is now finished, the report's finished, and we're hoping to issue that decision tomorrow, or certainly by the end of this week. So that's the live and latest update on that application. And again, just for the inspector's benefit, there was a previous consent on that site for 28 units that had expired. So this latest application picks up some of the work that was done through that previous consent.
Yeah, this is a really minor comment that I just picked up when I was just reviewing this again yesterday. Criteria G contains the words "if required" twice. It's only a typo, it doesn't matter or affect anything, but it just might be sensible just to suggest that as a a minor modification. Yeah, there was a bit of a question on access on that site. Yeah, do you want to comment?
Just that I think the LPA issuing a decision, positive decision on the application, and all the issues of access have been considered through the application process, and there is an appropriate access that can be provided, and any subsequent matters dealt with by a condition. We're comfortable as an LPA that access is achievable to allow that site to come forward.
So just to be clear, it's the same access as the previous consent, is it?
Yes, it is. Yep.
Yeah. Yeah, and there was a bit of a query about accessing neighbouring sites if they were to come forward in the future. Yeah, the policy, I think is it in the policy or is it in the background justification, says proposals should not prevent adjacent sites coming forward. Oh, sorry, it's in the site specific requirements. Is that sufficient to enable the access to those neighbouring sites?
I think from our perspective as plan makers, it is, and obviously through the current development management process in terms of assessing that application, that's also an issue that would have been considered by the case officer in the layout of the scheme. So that we're comfortable that both from a plan making and decision making perspective, that we're not prejudicing anything that may occur in the future.
Okay, thank you. I think that's something for us to go away and think about. That. Yeah, thank you. That's helpful. And then I didn't have any other sites to ask questions on in the West Medina regeneration area, but if anyone's got anything else in that area that they want to mention.
So just as a matter of, I think, geographic accuracy, in matter 6, issue 2, item A, the first site we think is in the West Medina regeneration area because it's in Cowes rather than in East Cowes.
Which site again?
So matter 6, issue 2, item A, Greengate Industrial Estate, HA 018. And on page 211 of the IPS, it's identified as this is the Thetis Road site. I mean, it's all rather academic because of what we tell you when we deal with that site. It's just that geographically we think it's in West Medina regeneration area rather than East.
Yeah. I thought I'd taken that list from your appendix, but I'd clearly got that wrong. So I take your point, but I'm not sure that affects anything other than my agenda. So yes, no, that's a fair point. And I think that is the next site on the list anyway. So we'll go through that next. So yeah, this site, perhaps it making that even less relevant, is proposed for removal in the statement of common ground with the Environment Agency, presumably due to the risk of flooding. I mean, I think that's pretty clear, but is there anything else you want to say on?
Yeah, thanks. No, just to confirm that as a result of our ongoing conversations with the Environment Agency and the kind of updating of the site summary sheets that we referenced last week, that unfortunately shows that site is not appropriate for allocation. So we are proposing to remove that. I'll just flag, given that when we submitted that statement of common ground, that was post submission of our Matter 7 hearing statement. So those 20 units are still included on our housing trajectory in that Matter 7 hearing statement, albeit we've got a 9% buffer that we're showing within that. I'm sure we'll talk about that in a bit more detail tomorrow, but just for clarification, so you're aware that 20 still appears in those figures in our Matter 7 hearing statement. They would need to come out.
I suspect we've already covered the answers to this, but that site is directly next door to the Medina Yard site, isn't it?
That's correct. Yes.
Yeah.
Yeah.
And I think you answered the question, didn't you? About yeah, the question I was going to ask was an update on the planning permission on that, because the reference number was very old, so I don't know what date it was issued, but I think you'd already addressed that by saying, I think you said it had expired, so therefore it would need a whole new planning permission anyway. It's not like it was either extant or been implemented.
No, that's entirely correct. So I think it was a 2016 application. I think originally, I think we may determined it 2020 or issued the permission in 21, and expired in 2024, not long after we published the Reg 19 version. So yeah, that's why that site's been removed. It would need a whole new planning application. As I say, we're aware that the new owners of the site have a potential different direction, which may also potentially impact the Thetis site to the south as well, in terms of employment use.
Thank you. Yeah, I think you've answered all of my questions on that particular point. Yep. And then the next one I have on my list is land at Crossways in East Cowes. Yep, and you've made a very minor change to the appendix. Well, I say it's very minor, it's just a change of a word, but on the other hand, it refers to a somewhere completely different location in the document, but it does correct something. Yeah, and I picked up something suggesting that there should be a reference to a proportionate heritage impact assessment in the site-specific requirements. Do you want to say anything on?
Thanks. Yeah, just to confirm that we had incorrectly identified it as being a kind of generic, right, and it has got site-specific requirements on page 223. So that modification is just to pick up that point. And then yes, we had a conversation and representation from Historic England over the potential proximity of that site, albeit across the other side of the road to Osborne House. And again, I think through CD7, we've just suggested an additional line in that site-specific requirement to cover that point off.
Yep, thank you. I think that covers that, and that was all the sites I had in the, I hesitate to say it in case I've got it wrong again, East Medina regeneration area, but if there's any others anyone wants to comment on. No. Sorry, Mr.
Just coming back to the geography. So the red funnel site is technically is in the East Medina regeneration area. I probably should have block this as part of the discussion under matter 8. So looking at the council's statement at page 25 in terms of potential proposed changes to this site allocation, we've discussed there's obviously a slight amendment in terms of the number of housing, but the commercial floor space is obviously coming down quite significantly. Is that a reflection? So this is a site that's we've been obviously looked at various sites. This is allied to or part of the wider red funnel operation at East Cowes. What's being proposed doesn't materially affect their ferry capabilities and connectivity to the island at that point. But in terms of just, I appreciate this is slightly off topic, but just in terms of what's driving or potentially driving these proposed changes, is that a reflection of their readjustment of what they're looking to do on that particular part of the site?
The short answer is yes, it is. So the proposals that are coming forward for Funnel don't impact their ability to operate that ferry terminal. As a brief bit of history, so the marshalling yards, which is effectively where the cars obviously wait for boarding the ferry, they potentially will move to the north of where they are at the moment, and that releases some of the land that's currently used as marshalling yard for potential development, which is the approach that's been taken through the application. So again, there have been previous applications on this site that handled that moving of the marshalling yard and creation of development space, and this application reflects the most up-to-date position from Red Funnel in terms of their operational requirements and the surplus land that would then be generated by that new marshalling yard, which is effectively going to manage traffic better in terms of accessing the ferry.
Thank you. And then follow up and just going back to the statement of common ground with the Environment Agency. So on one side of the Medina, the site is coming out. This is obviously on the other side of the Medina and it's still in. But I think the Environment Agency have reached a position, I think, of agreement that some additional text to cross-refer back to the latest strategic flood risk assessment summary spreadsheet, so we can conclude from that the Environment Agency have no sort of in principle objection to what's proposed in the plan, subject to that modification.
Yes, absolutely right. So the updated site summary sheets we touched on last week will be reflected obviously in the site specific requirements for that site. So should the current application get permission and then that permission expire as previously happened on Red Funnel, then that would still be there in the plan as something that a development scheme would have to pick up. But obviously from a point in terms of the application that the LPA has at the moment, the EA have no objection to the principles of that planning application. That's their position on that. So we're comfortable both from a plan making and decision making perspective that that site's appropriate.
Okay, in which case turn to the ride regeneration area, and the first site on that list is Penny Feathers. Now, this is probably where the biggest change to the housing trajectory comes in, because you've added, you've shown an increase from 290 to 700. Oh, yeah, sorry, I'm getting confused by my figures because it's 700 within the plan period, but you're expecting another 100 or so to come forward later. Do you want to say anything about why you've done that? I mean, I think it's fairly clear from the representation submitted, but give you the opportunity to comment if you want to.
Thank you. Yeah, I'll keep it very brief. So obviously at the time when we published the submission version of the plan, the pre-app conversations that we were having with the promoters and developers of that site were obviously at an earlier stage than they are at the moment. Obviously, we're encouraged by the representations that we received through the process, and we've adjusted our housing trajectory accordingly in terms of what the LPA considered to be appropriate for that. And yeah, picked up in our responses to 6.25. So we've got nothing further to add really on that point, other than obviously welcoming the the positive conversations that we continue to have with the promoters of that site.
Now, there was a previous planning permission on this site, which presumably has expired. Do you want to? I mean, I think logically, if there's a previous planning permission on the site like that that's expired, we need to have sort of reasonable to have some concerns that it's not going to come forward again. So perhaps, do you want to comment on why you're so confident? I mean, you've mentioned discussions with the landowners and developers already, but perhaps you could perhaps give a bit more confidence to that, if you like, or detail.
Yeah, certainly I'll start, and I'm pretty certain colleagues across the room would like to come in as well on that point. So from our position as LPA, yes, there was a previous outline permission on that site. There was then a subsequent reserve matters, which was refused at planning committee on some issues around layout. And obviously then by that time, the original outline had expired. I believe, and it goes back for my time at the LPA, but there were some challenging land ownership issues, I think, which may have changed. I'm sure colleagues across the room can cover that off. But from our perspective as plan makers, and I think we touched on this last week to a certain extent, you know, we aren't blessed with large strategic sites on the island. So we're very keen to ensure that those that are being promoted, if we think they're suitable from a sustainability perspective, that we will have those positive conversations, and if we think they align with the spatial strategy from a plan making perspective, and they align with our housing requirement, then obviously that's the position that we would take. From a confidence perspective, obviously we, again, as LPA, are in detailed pre-app conversations with the promoters of this site. The indications we've got are all positive in terms of that site coming forward and coming to market. So again, from our position of certainty of delivery, then that's a positive position for us to be in as LPA, from a plan making perspective, that allows us to have confidence in that allocation.
Thank you. Ms. Goodyear, do you want to come?
Yeah, just to help really, to say we're in the process of preparing a hybrid planning application at the moment, hoping that we can submit that by the end of April this year. So we've done quite a lot of work to date on moving that forward. We've done all the ecology surveys, etc., and we're working on a new highway solution that will help improve the scheme. So yes, if there's any sort of extra questions, we're here. We're obviously working for the landowner and pushing it forward.
I think you've implied that this has been resolved, but perhaps you could clarify. Mr. Brewer mentioned something about challenging land ownership issues. Perhaps you could say.
Yes, mate. Not particularly challenging. There were various bits and pieces of contracts that were due to expire as we were getting towards the end of the contracts, but they've all been resolved. We are in control of all of the site, as we were at the reserve matters stage 2. But that was the challenge, was the reserve matters was running out, as were the contracts on the land at that time. Hope that clarifies that. Just one thing in terms of history, just so that you put on the background of the history to that, we had the option of appealing, but because it was a 2015 planning application at the time that was the outline, obviously as time progresses, the description of that and the progress of that application moves forward. It was better and thought better to actually come back in with a fresh application rather than try to keep the old application alive. It allowed us to come out with a completely fresh approach.
Okay, so in summary, there's if it was allocated, I mean, sorry, the planning application is due probably hopefully in April. If it was allocated, I can have confidence that it's going to be granted planning permission at some stage, hopefully, and be developed in line with the trajectory that's been put forward. That's the summary on that side. Yeah. Okay. Thank you. That's helpful.
Yeah, and I think echo that entirely. And I guess the changing trajectory on this site is, I guess, is a good example of kind of how we tried to approach the housing trajectory in the plan from that bottom up kind of almost site by site approach, really, which we'll obviously come on to in a bit more detail tomorrow. So we're looking at each of those individual sites and what we think they can deliver in the short, medium, and long term. So and again, it's reflective of the positive discussions that we're having with the promoters of that site.
Thank you. And you've suggested a minor modification to clarify that SANGs may not be necessary as mitigation, just to
Yes.
say why that is as well.
Sorry, yeah. So obviously, we're again, as part of the detailed pre-application work that's been gone, we're aware of the developer having gone through the discretionary advice service from Natural England on this particular topic. And I think, as we discussed yesterday, we'll probably discuss a bit more this afternoon on that particular policy around the mitigation for the overwintering birds. Obviously, SANGs is one particular way of providing mitigation. There's also a financial contribution that can be made to a strategic mitigation package. So they're both options. We're aware of the advice Natural England given to the developers on this site. Obviously, again, what we're trying to do in the plan is cover off as many eventualities as we can. So if for whatever reason the application that's forthcoming to us went down the same journey as the previous one, then we want to make sure that future development applications could potentially provide SANGs as part of, or that could be part of the mitigation package if it were necessary at that time. So again, we're just making sure that we're not kind of fixing ourselves on one mitigation solution when others may be available in the future if required.
Okay, thank you. Yeah.
Thank you. Just on the, coming back to our MIQ 625, so the council's putting this forward as an allocation, I think I'm right in saying as at least 800. That's a floor, not a ceiling. I'm right to understand from Bell, Cornwall and others that you think a more sort of optimistic or a higher figure or a higher capacity for that site might be necessary for plan soundness, that this is a site that can accommodate more than 800, not just marginally more than 800.
Well, to help, we're working, the hybrid application at the moment is looking at 900 dwellings. So the policy is over 800. So, I mean, within reason. But that's where we are and what we're working on. We've done quite a lot of detailed master planning work to get to that figure. So pretty confident with that. And the previous application was a similar level. I just wanted to add on the SANGs as well. We obviously met with, just to clarify, we met with Natural England back in the summer as part of our pre-application work, and they confirmed that the site was too far away from the coast to require the SANG, so the contribution to bird aware would be acceptable. So as long as there's the flexibility in the policy to allow that to happen, we're happy.
From the council's perspective on this figure of sort of at least 800, appreciate it is expressed as a minimum, but sometimes in practical terms, when decision makers are looking at something, they see 800 and may find it challenging to kind of step too far away from that figure. Is there the evidence at this stage, and how, in terms of either how the council's looked at the capacity of this site, or from the alternative evidence that's been presented through the site promoters, to say that 800 figure remains appropriate, or whether there's something at this stage that could say, actually, this is a site that could accommodate more than, I mean, the site promoters are saying 900, whether it's ultimately that figure, but should we be concerned about something being presented at least 800 if there's a kind of potentially some recognition or reflection that this is a site subject to that could accommodate a materially different number, which I think 900 would be.
Thanks, sir. And I think our position on it, as we've set out in our response to 6.25, obviously at the time of submission, the pre-app conversations were at a certain point. So we haven't yet seen kind of those layout work that's been undertaken by the developers. So obviously for us as decision makers, that's quite a key thing that we need to get our heads around, just to see how the site works from that perspective. As I'm sure everyone in the room is aware, those conversations will potentially result in adjustments to layouts or numbers. We don't know because we don't have that as yet. I think as Mr. Farrell said earlier, you know, the previous scheme of 903 or 4, I think it was 904, thank you, was obviously of its time. Many things have changed since then from a policy perspective, some of which do affect land take when we think about things like biodiversity net gain, the requirement to kind of separate surface water, all those kind of things. So I guess as plan makers at this stage, we're comfortable with what we've got in there. We believe that at least 800 allows for that flexibility. I think, as we note, the screening kind of said up to 900, so we're in a round of 100. So from our perspective, we're comfortable with that. And again, from a decision-making perspective, you know, the wording is there, it's clear, it's at least 800. And I think, you know, throughout that application process, I'm sure that the promoters will be making their points around how that site works, using some of the history potentially, and we'll review that as we go through. But from a plan perspective, we're comfortable. We appreciate that the site could be somewhere in between that 800-900. We just perhaps don't have that kind of certainty through some of the work we've seen so far, because we haven't commented on it yet. That's it's not we're not saying it can't happen. We just need to kind of have that next stage of detail in terms of the pre-app conversations.
So I think, yes, I think we would be concerned, although it's not quite the same as an outline planning permission, because obviously if you've got an outline planning permission which specifies a number of units, then a developer is entitled to put forward reserve matters up to that level, and it wouldn't be obviously a ground or a proper ground of rejection of those reserve matters, simply the number. Obviously, a local plan allocation is not quite as advanced as an outline planning permission, but given that planning applications would then have to be determined in accordance with the development plan, unless material considerations indicated otherwise, one would be running the risk, if one specified a number that we haven't yet had an adequate demonstration is achievable in a satisfactory manner, there would be a risk that the planning authority would then be faced with an argument of, well, your policy says number X, and therefore you can't, as it were, now raise issues which seek to suggest that the site doesn't have capacity for X. If you wanted to do that, you should have done that at the allocation stage. And that's the, you know, whereas we see the, as it were, the other side of the coin, saying at least 800 is very clear that that is not a ceiling or a maximum, and therefore it opens the door to more, but it doesn't commit to more until we're, as it were, shown that that more can be achieved in a satisfactory fashion. So I think we feel more comfortable with our wording, and we don't think that we are, in a sense, selling anybody short or at risk of, as it were, losing available capacity, but we just would be cautious about going beyond that, and then that becoming, as it were, a difficulty for us if it then turned out that actually there were issues with the higher number. So that's in a sense our thinking.
Thank you. For Bell Cornway, I'm assuming you'd see things the other way round to sort of set an alternative figure now for soundness.
I was just going to respond to a couple of points, I suppose, like land take does change, but the outline application included land for a school, which is no longer required. It also included sang, which is no longer required. So yes, there's now biodiversity net gain, but other things have come out into the mix. And I just want to say, sort of point out really, the reserve matters application was for the whole site for the 904 dwellings. So it did confirm that that could be accommodated on the site at that time. And it was recommended for approval by officers, and it was refused on the basis of cycle and pedestrian links and the location of the community centre. So it wasn't anything to do really with the number and capacity of the site in that sense. So I think that can give the council and hopefully both of you the confidence that this site can deliver that 900 figure.
Mr. Brewer, thank you.
Thank you, and yeah, appreciate all the comments made, and probably just the final point for me would be, you know, depending on what the inspectors come to on that particular topic, we're probably looking at the back end of the plan period for those, you know, if they were additional numbers, if it's, you know, obviously we've got in there 700 the plan period from at least 800. If the view is taken that number increases, then they're going to be at the back end of the plan period. And obviously we've already touched on last week in terms of the likely plan reviews and all the stage we'll get to before then. So I suspect there'll be another conversation around where that site is at a moment in time in terms of plan making. So just to flag that really.
So final point on from me, you'll be pleased to hear on just this site and location. Some of you may recall in week 1 when we were looking at the housing requirement last week around the ability of this plan to test the appetite, if you like, of the national house builder sector coming to the island. Is this, in terms of its scale, obviously it's a large strategic site in the council's mind, is this a site that would kind of fit that category in terms of potentially attracting national house builder activity? Similarly, is this a site, apologies, and small developments might be able to tell me who they are and where they see their role in this, in terms of, obviously without prejudice to any kind of separate kind of commercial discussions you may be having, but I mean, coming back to the council, it's your plan. Is this the sort of site that you'd have in mind? Coming back to the concerns that were raised last week about, is this a plan that can potentially attract or stimulate national house builder interest on the island?
Yes, absolutely. We think it is one of those sites that could do that. And again, it's part of that kind of package of sites of scale and location that we've tried to include in this plan to be able to do many things. So that's appeal to national house builders, appeal to the larger house builders, such as the island, the smaller sites as well. So from our perspective, absolutely is, and I'm sure colleagues may want to comment on that further.
Yeah, just to confirm, yeah, obviously as part of our remit, we're talking with numerous developers of medium scale upwards, and national house builders are in that mix as well. It depends on how things pan out, obviously, is the planning application, timing, that sort of thing. But the normal players that you would expect to be interested in this area, this particular site, have registered interest.
Sorry, we're just discussing when it's sensible to take a break, and given where we are on the agenda, we think probably now, which is a bit early, but yeah, we've got through quite a bit fairly quickly. So should we come back at 20 past? Thank you. Okay, I make it just after 20 past, so time to restart. So moving on to West Wight regeneration area, and I'm going to, the first site is Camp Road. I wanted to approach this in a slightly different way, I think, to see, using this site just to understand how policies hang together, if you like. So policy H2 on sites allocated for housing, it says, got the first paragraph which ends in accordance with, and then you've got four criteria, the last of which is all other relevant development policy requirements set out in this plan. And then you've suggested some changes to paragraph 7.22 that deal with that issue. And the original text, just because that's what I've got in front of me, and I think what you've changed it to just makes it a bit clearer rather than changing what it actually said. Says incorporating any other island planning strategy requirements where applicable, but the policy itself I think carries much more weight, and that just says all other relevant policy requirements set out in this plan. And then I think in relation to this particular site, policy EV8, first part of the policy says the best and most versatile agricultural land will be protected from development not associated with agriculture or forestry, except where A, development is small scale, and B, which deals with development aimed at achieving long-term viability of a farm. Now, I think the problem, what my concern with this site is that it seems fairly, it'd be all right if you granted planning permission today because the plan isn't adopted, but once the plan is adopted, it seems to be obviously contrary to those policies. And I just wanted to be clear that I understand where you're coming from on this site in particular, reading through those policies. But Mr. Brewer, yeah.
Thank you, sir. And I think we've suggested amendment to paragraph 7.22, and we just to make clear that obviously sites that are allocated, effectively the land use principle of those sites is acceptable through that allocation process. So effectively that's the starting point, and obviously there will be policies in the plan such as EV8 that you refer to which deal with the land use principle of a scheme coming forward, but that would be for sites that aren't allocated and the sites potentially come forward in the plan period. So the approach is on this and others from that land use principle perspective, and we've hopefully tried to clarify that through the additional wording to 7.22. I think again we also talked to, I think paragraph I think it's earlier on in chapter 7, and I'll just find the reference in a second. But yeah, so that adjustment 722 and that kind of starting point from our perspective is that, you know, the basic land use principle of sites is acceptable through their allocation. Obviously, we do need policies that relate to land use principle for other schemes that may come forward during the plan period. So that's how that's set out.
So I think we can sort of see your reasons for raising this as an issue, but we think that it's answered by the use of the word relevant in criterion D of policy H2. And you have to ask yourself, in a sense, well, what does relevant mean in the context of an allocated site? Because if you accept that the purpose of an allocation is to settle the principle of development on a site, and that therefore the allocation decision resolves that point of principle in favour of that site being allocated for development, it necessarily follows that you or at least the person who's made the allocation choice will have weighed any constraints which go against allocation in the allocation decision. So it would be, as it were, not relevant to repeat that exercise at the development management stage by applying policies which go to that point of principle to the allocation, because you would be not then reading the plan as a whole, because the policies are intended to work together and consistently, and therefore when you've got a policy which deals with issues of principle, they would not be applicable to an allocated site, because the allocation decision will have grappled already with those issues of principle. So I think that's what we think flows from the use of the word relevant in H2 criterion D, and that's what we think we've expanded on in the recommended suggestion that we've added to paragraph 7.22. But we're perfectly happy in a sense to look at that again if you think, well, that's not as clear cut as it ought to be, and if you think that it's leaving open for decision makers in due course that they might have to reapply in principle policies to allocations, then I think we would want to think about, well, we need to make it clearer and we need to add some further wording to articulate that point. I say we think we've done enough, but we're very open to any suggestion that, well, no, you've not made it clear enough, and therefore we would look at it again to see how we can deal with the point. But we do think the basic point is when you allocate sites, you're making a decision on the land use principle, and therefore policies which relate to principle shouldn't come back again at the DM stage, because it would be repetitive and it would undermine the whole purpose of making allocations.
Yeah, I understand. I think I understand what you're saying. I think I would read the word relevant in a different way, which I think is what my concern is, because I think I'd read relevant as in if the land is on a certain agricultural land classification, that policy relating to that, which is policy EV8, must be relevant. So I think when you say you're happy to have a look at it again, I think that's really what you need to do. I think the way you've revised paragraph 7.2 is fairly clear, but I think the problem is with that, the way the policy is worded, and that I think other people will come to the same conclusion that I did on reading the word relevant. So either you need to be a bit more explicit in the background text, or reword the policy. But I think the background text is possibly a bit hidden. So it might be that the policy needs to have another thing. I mean, I don't know what the solution is. I haven't got that far, but perhaps you do, or you go away and think about it and come back with something. Mr.
Thank you, sir. Yeah, it may well be we just look to potentially lift the wording or the adjusted wording from 722 into policy, and then it's really clear then about what we're meaning, and it's in a policy box. So I think that would be our probably starting point of looking to address that issue of just lifting the revised 722 wording into policy, so that there's absolute clarity then about that. And as you say, it's not in supporting text.
Yeah, and in doing that, I think you need to be mindful of what policies this affects, because there's always the risk that someone then argues that any policy is irrelevant because, and there's some policies that clearly must be relevant, like ones looking after living conditions of neighbouring occupiers, for example. You don't want someone to try and argue that that's not relevant because of the way you've worded it. But yeah, I think possibly that's the answer, to go away and have another think about that.
I think probably what's partly in our sort of thought process and just picking up kind of themes from the evidence and the discussions over the last sort of week or two is, notwithstanding setting the principle of sites within the plan and the weight to be given to that as an allocation, whether at the decision-making stage, for whatever reasons, and I don't know how far we can go in terms of providing the desirable kind of flow of certainty that once a site is allocated and the principle is established, it's then not unduly kind of unpicked when it comes to the crunch of actually then making decisions at either outline, full or reserve matter stage. You know, that ship has sailed, the principle is established, irrespective of perhaps some of these issues, and you know, that's some caution to ensure that's clearly understood, and to provide that kind of safeguard and assurance. I mean, we can obviously go away and think about further whether proposed changes to paragraph 722 get to that point, or whether, as Mr. Brewer says and Steen's picked up, whether we need to look further at providing some sort of further assurance in the policy. I mean, obviously we looked at this as part through the discussion last week on site selection and the strategic housing land availability assessment, which we thought at a relatively high level, when we get to things like agricultural land quality, be sieving out some sites, but obviously we're going to come on to a particular site in freshwater where the council through plan making is looking at a site on best and most versatile agricultural land. Mr. Bedford.
Well, yes, so I think we do want to think about adding some further wording to make our position quite clear, but in the 2012 Local Planning England regulations, there is a definition in Regulation 2 of a site allocation policy, and it simply states site allocation policy means a policy which allocates a site for a particular use or development. And I think that's, in a sense, what we think flows from an allocation, that the use or development which is then identified in that policy is established by that policy. And so I think what we've just simply got to make sure that we do is have sufficient text in the plan, preferably somewhere in a policy box, to articulate that any other policy which simply goes to the principle of development is not to be then applied to sites which have secured an allocation. I think that's what we want to achieve, and I say it's just the way of doing it. I've certainly seen in some other plans that they have either on the policies map or by a whole series of asterisks, ways of, as it were, flagging up which policies apply to which areas, but that can be quite a complicated process. So if we can do it in text form, I think that's probably what we'll try to do. But I think we're agreed about what needs to be done. It's just trying to find a route that successfully does that.
Yeah, I think that's right, and I think that's the tricky bit. But yeah, you've highlighted the issues with that, and yeah, so something to go away and think about, I think. And it's the Camp Road site that sort of highlights that issue most starkly, particularly with regard to the agricultural land classification. I think you gave a fairly full response, so I'm not sure there's an awful lot more that we need to go through on it. Beyond that, there was an issue about proportionate heritage impact assessments and whether that's properly reflected in the site-specific requirements. It looked like you were going to say something else, but perhaps you could address that comment and anything else you were going to say.
Yeah, thank you, sir. And yeah, no, firstly, I'd say, yeah, we've given quite a detailed response in our hearing statement on 6.17. So we don't necessarily have anything else to add on that particular issue. In terms of that point A and the designated heritage asset, again, I think we're probably benefiting from the status of the site in the planning process, in that we've had a very detailed committee report for that site, which considered that issue in detail. And as we reference in point A, that wasn't one of the reasons for refusal. The impact was assessed. So from a plan making stage, we're comfortable that there doesn't need to be any adjustment to that, given the quite comprehensive work that's been undertaken through that application process. Obviously, if inspectors were minded otherwise, then I'm sure we can come up with some additional wording or addition to the site specific requirement. But as I say, we'll lean on our responses to 6.17. Thank you.
Have you, I can't remember seeing it, but I don't think you've amended that site-specific requirement on that site to reflect our heritage. Because at the moment it talks about archaeological assessments, but doesn't really deal with other historic or heritage assets, and there were quite a few. I know the conclusion in the officer report, but if another scheme that wasn't built out for whatever reason, and another scheme came in, I mean, the grade 1, I think it is, listed building at Farrington House seems to be quite important to reflect that and the other heritage assets in the vicinity in those site-specific requirements.
Thank you, sir. And I think, yeah, again, I'd point to paragraph 7117 to 7124 of the committee report, which obviously I'm sure you've seen and provided a copy you of. And I think from the detailed assessment of those issues, both the distances of some of those assets, 150, 190 metres from the site, and the fact that there's quite dense woodland in between them on a number of occasions, from our perspective, both at plan making, decision making, they aren't issues effectively that are going to affect the development coming forward on that site. And I think we've done, say, quite a detailed appraisal of that through the decision making process we've been through at the moment. So we're comfortable from plan making that everything's in the site specific requirements that could impact a potential future scheme, if one came forward, is in there. So.
Yeah, I guess the way I looked at it was I read those paragraphs, and the conclusion on all of the heritage assets seemed to be that there wasn't harm to the setting. But what you're saying to me is almost that they didn't affect the setting. But I think there's a subtle difference between the two. And if the issue is that they didn't harm the setting, then I think I'd have expected reference in the site-specific requirements. If they were outside the setting, then perhaps they didn't. I mean, that was my reading of the officer report. I'm not. Yeah, I think I'll leave it at that. But yeah, do you want to respond?
As I say, no, it's a fair comment. And I think, if the inspectors were minded, then I'm sure an additional bullet in the site specific requirements that generically covers that point off could be added. We would have no issue with that. Just from our perspective, they don't form major issues, but I'll say we'll leave that one there, I think.
Okay, well, that can be something that we can go away and have a think about. Yeah, I mean, the only other thing was about the settlement gaps. I'm not sure there's a lot more that needs to be said about that, but yeah, because there is a settlement gap between freshwater and topland, and you've drawn the line to include this land within the settlement because it's an allocation, which I understand why you've done that. But it is quite a large patch of undeveloped land in what would be that gap if it wasn't for where you've drawn the line. So do you want to make any comments on that?
Not really anything to add over and above what we said in point D to 6.17. Also, questions 417 and 418, we went into quite a bit of detail about this particular issue in terms of fresh water. So we'll just rely on our hearing statements for the information that the inspectors need on that issue.
Okay, thank you. Yeah, and we'll come back this afternoon to certainly what you've answered on 4.17 to 4.18, because that's part of the environment chapter. Okay, I think I've covered everything I was expecting to on Camp Road. So we'll move on to Heathfield campsite. And it seems to me we had a query. Let me just find it here. Yeah, we had a query about the scheduled monument, but you've suggested. Yeah, you've said inclusion of mention of the nearby scheduled ancient monument of Golden Hill Fort provides greater clarification in terms of the impact any development scheme should consider. So that's been put forward. Just remind me where.
Yes, that's correct. So document CD7, which it obviously partly fell out of our statement of common ground with Historic England. So that picks up that point. And I suppose the difference to the conversation we've just had is we don't have that detailed appraisal through the application process of that particular issue. So that's for consistency purposes why obviously we're suggesting it should go into this one. And proximity as well.
Okay, thank you. And then the next thing on the agenda is any other sites in the West Wight regeneration area that anyone wants to make any comment on? No? Thank you. In which case, sorry. Mr.
So just for my benefit, if for nobody else's, I mean, when we picked this issue up at the I think, yes, under site selection last week, I think we thought it was noteworthy that there was have been representations on the plan, relatively few in relation to some of the sites proposed. And I think the council kind of provided an explanation that a number of these sites are sort of now perhaps well established in the psyche of island residents and the island community. But obviously some of the sites in freshwater did attract a number of representations at regulation 19, particularly in relation to the Camp Road site, and obviously asked specific questions about that. But just if the council can help me in terms of just a general overview of sort of the site selection process for freshwater. Clearly the Camp Road site has generated a number of local concerns about its potential impact. When you went through the kind of the higher level kind of site sieving sort of process for freshwater, having established through or considered through the strategy that it was a location for a sustainable location for some further development, why does it kind of fall out of the process that sites like Camp Road are reasonable options? Are there other high level constraints within the kind of the freshwater topland area that would lead a plan maker to say, you know, these are the locations we would have to look at, because other, notwithstanding its agricultural land quality, because there are other things that we need to look at. Probably that's probably more for my benefit from if nobody else's, but maybe it'd help Mr. Brewer. Looking around, I don't think have got anybody here in the room from freshwater or representing freshwater. People may be joining, maybe observing on screen. Mr. Bolt, you were.
It was only to say that I'm from freshwater. Originally, as it were.
But you haven't made regulation 19 reps saying that this plan is unsound and.
I certainly wouldn't have made representations in that way, no, sir.
I was just for our benefit, I was kind of looking at the screen and trying to think, oh, is there any? But, okay. Thank you. Sorry, Mr. Brewer, back to my sort of general points about the kind of the general approach to sites in freshwater.
Thank you, sir. And yeah, again, trying to kind of lift it up to that kind of strategic perspective. And I guess a really good example is the map extract we included on page 18 of our Matter 6 hearing statement, which the yellow that wraps around freshwater is national landscape. So in terms of constraint and the ability of where to look, that is a significant one. So when you're looking at potential spatial locations for further development, that plays a significant role. And again, when you look at the particular site that we've just spoken about, you know, there is residential wrapping around 2, if not 2.5 sides of that site. So again, when you're looking at potential options as a plan maker and a spatial planner, then obviously that's one of the considerations you look at as well. And I think the further you go away, probably to the west into that gap, the more you start to impact that potential settlement gap. So again, when we're looking at some of the locations that we've chosen, that forms part of the thinking as well. And obviously marrying up all of those different constraints, not least sites being promoted and that are available as well. And we have to take that into consideration. And, you know, whilst you could identify different bits of land that may be, if they're not being promoted and they're not available, then obviously that's part of the thinking as well. So there's a number of factors that go into it. But I think, you know, certainly from a kind of freshwater perspective, we had to take the view that there are a number of wider constraints in play when you look at kind of zooming out from the settlement. So therefore that does kind of drill you into 1 or 2 specific locations when you're looking at what from a plan making perspective, we think is most appropriate.
Thank you. And just briefly in follow up to that, I think we asked it as part of the habitat regulation assessment, our habitat regulation assessment questions, and I'm trying to recollect my memory in terms of how far the national sites network or Ramsar site designations wrap around. Because I think in some of the representations people were referring to, is it the Yar estuary or the Yar inlet? And I see as part of the council's response to our MIQ 617, the most recent application, one of the reasons for refusal was in relation to habitat regulations. Is this a fundamental showstopper or an issue that can be addressed with further evidence?
The short answer is it's not a fundamental showstopper. It's down to lack of information provided from that scheme. So from our perspective as plan making, it's not a showstopper. It's a hurdle that can be jumped over. But you're right, in terms of some of those Ramsar designations around the Yar, that starts to have a real impact towards that kind of northeast of freshwater when you're looking at some of those areas. So again, when you've got the national landscape as well, you're starting to put together a package of quite significant constraints that kind of almost rule out quite significant areas of expansion for that settlement. So you become a slightly more focused in some of the areas that you have to look. And that's one of the, obviously, certainly the considerations we took through our site selection and plan making process.
Okay, thank you. Yeah, so next on the agenda, I've got other regeneration areas and any other sites. I've got a couple of other questions, I think, that I'll come back to. Yeah, you updated details on Harcourt Sands Holiday Park at the end of your answer to our MIQs. Yeah, you've adjusted the numbers and it looks like you've adjusted the location, although I think that's to do with parish boundaries. Is there anything you want to say on that before we move on?
Not in any detail other than just to confirm those 2 points. So we haven't, the number in terms of the yield of the site hasn't changed, and that's reflective of the permission that exists on that site. However, we're in this slightly bizarre situation where obviously the site itself is in a particular ward, but from a plan making perspective, it's in the settlement of Ryde because of its location. So it was just effectively to factually correct that within the policy. So that's nothing further to add on that. The numbers themselves of the site hasn't changed at all. And nor has the approach to what that means to designated neighbourhood areas, because the approach we've taken is simply to identify all those sites that have permission. And then, as we touched on last week, windfall allowance to come across the plan period.
Okay, thank you. Yeah, sorry, this is perhaps going back to something from Friday, but just to check, just on the, we may have asked it on Friday, I just forgot, but I was going through the statement of common ground from the EA, and that mentions Sylvan Drive in Newport, and whether there's any change or anything on that, just to allow you final opportunity to comment on that.
No, other than say, obviously, the updated site summary sheet was agreed by the EA. There's a planning application currently in for that site. I think we'll probably touch on it this afternoon in terms of our river corridor buffers policy. That's quite a neat example of how that policy plays out in action in terms of those buffers being incorporated within the development site and having a role to play in providing biodiversity benefits. So yeah, nothing further to add on that one.
Thank you. And then there was something, I think it came from Heritage England, about on archaeology, and your updated policy shown on document CD7. Whether there needs to be a change, because I think they've suggested wording to record where appropriate and assess the relevant impacts and mitigation aspects. Yeah, whether that's clear. Do you want to comment on that?
Yeah, thank you, sir. And yeah, as we picked up in our response to 6.29, we are suggesting in document CD7 an additional site-specific requirement on some of those sites relating directly to archaeology in the Historic Environment Service. So again, that reflects comments from that particular part of the council and also Historic England. So, and from our view, that's just necessary to ensure consistency with national policy, particularly paragraph 200 of the NPPF.
Yeah, we did have one thing that's sort of come out from just having a look through sort of planning histories and dealing with planning applications, and perhaps a bit of a tough question, but there seems to be, but it's just an opportunity for you to comment on it. It's just something that we just noticed, but there seems to be quite a big gap between planning applications being submitted and decisions coming out, and they seem to take quite a long time. Do you want to comment on that? Is there something you can say about that?
I guess very briefly, there are always occasions when applications are submitted and then the time to get to a decision is extended. There are very many reasons for that, and often case specific and site specific, not least through changes in circumstances, changes in views, consultees, etc. There are other occasions where applications will come in and will be dealt with swiftly. I'm sure others in the room will have a view, but I guess in some ways it's almost reflective of planning in general. I think at the moment that the time and information required to support a planning application is significant. The level of detail that's needed is significant, and sometimes getting into some of that detail requires further work, and obviously the complexities of some sites mean that can take a time. So I don't think there's a necessarily one reason or one issue that's island specific for it. Obviously the resources of the LPA play a part, and that's kind of been on an upward trajectory, and I'm sure Mr. Balter will comment on that. So I guess from our perspective as plan makers, what we see is that a number of the sites in our supply are in the pipeline, they're in the trajectory through planning applications or decisions, or and we will take the view that that's a positive step from the development sector in terms of the submission of those applications, and we would always envisage that they will be dealt with in a timely manner unless circumstances dictate otherwise. So nothing really to add on that.
If I may just follow on from that, so I think I'd just also like to just highlight the LPA's mindset, I think, actually, when it comes to determining applications and thinking about the proactive working that we will look to undertake with an applicant to achieve a positive outcome wherever possible. And when applications are for land uses that the LPA can and the council can ultimately support, but perhaps through negotiation and revisions, can give an acceptable scheme, working towards an acceptable scheme rather than simply refusing at the first opportunity. Thank you.
So I think it may be something that's slightly reflected in our appeals experience, in the sense that partly because of the positive approach and the working relationships between a number of those promoting development on the island and the council's development management team, that whilst it's not always the case, it is often the case that applicants are content that problems can be worked through by further engagement and dialogue, rather than feeling that there needs to be an appeal because positions have crystallised, which is positive, but it does then have, as it were, the downside that then it takes applications quite a long time to go through the process. And it may be that in some other parts of the country, perhaps with different personalities at play, people have been quicker to press an appeal button and get into a, as it were, an appeal scenario, and that seems to happen a little bit less on the island.
Thanks, sir. I think I kind of touched on it last week. Some of the issues arising, Mr. Bedford touched on it last week, actually. SP1 has been both, it hasn't been it was a mechanism by the previous inspector to navigate around the lack of the AAPs at that time, but it was certainly neither, it was a conduit, but it was neither a benefit either, because it has run into significant challenges with the interpretation, particularly within the early days of SP1 and its usage. It took quite a few years to give confidence in the market to invest in the SP1 approach, and indeed, the first tranche of applications on a slightly larger scale were met with resistance on certain levels of the council, which led to a couple of appeals, which were then allowed by the inspectorate, and not for the local planning authority's own issue, but there has been struggles with the lack of allocations to give the continuity in community and at a political level to understand the plan-led approach. That has, again, it's a very macro issue, but it's led to a lot instability and lack of confidence because there hasn't been allocations. It spirals then because it raises the objection as a matter of principle of location against SP1. It creates tensions from a political perspective to get planning applications over the line, which has led to considerable delay. And I think in evidence is the peer review where it was noted against those tensions arising. And it's also led to a few challenges at a JR level. And if you look at the macro scale, this has led to quite significant delays in a pipeline, and it's also affected some of the major housing developers that I represent to get continuity in their supply pipeline. So the going between jobs, you have big gaps, and therefore you can't have a stability of workforce to go on to the next site because you're stuck on the first one, and then there's a big gap between the next one. That isn't the planning authority's failure. I don't see it, but it has the role of plan making at that strategic level and the stability it's caused against the SP1 era, and to some degree what we're facing now. And we then get into the micro where sites are stalled for whatever reason, and then certain elements, say, I don't know, for example, ecology becomes out of date because there's a cycle of 2 or 3 years where that information's valid, and therefore it's been hard for planning applications to catch up with themselves. As a consequence of one issue, you then lead on to another. I think, the desire to get a plan in place is the right thing to do to give the stability, whether there are elements of this plan that need addressing or on a micro or macro scale, that's to be determined, but to give the certainty and stability of a plan that has been lacking because of the SP1 territory has been a significant barrier to delivery and scaling up. As there's Mr. Gentleman talking about smaller buildings scaling up into bigger ones, it's been quite hard for smaller SMEs to scale up because of the risks involved. Thank you.
Thank you, Mr. Long. Does anyone want to say anything else on that point? No? Okay, thank you.
I'll just flag up now, we've obviously got matter 7 tomorrow, the first part of the morning. Is really around the sort of the housing trajectory. So I think where we look at the kind of the pipeline of what's coming through, I mean, nearly 3,000 allocations still to be delivered. So I think we want to, as part of that session, not necessarily for every site, you'll be pleased to hear within the trajectory, but more the sort of the generalities of, there are lead-in times, you are making an estimate in terms of forecasting when some of these sites are going to come and start building on the ground. And obviously part of that equation is the local authorities' resource capacity. I think Mr. Bolter referred to it as mindset, to kind of take what's in the plan strategy and again come back to giving us the kind of confidence. Yes, when we say this, we're looking at this happening in year 6, year 7. That's a reflection of all of these things. Obviously, we've got in the back of our minds some of the recommendations, something back to the Three Dragons report. There are things that appear to fall firmly in the local authorities' court in terms of actions and things that the council can do to kind of ensure that, hopefully through this plan, the pipeline of supply will come to fruition as kind of forecast and estimated. So we may want to come back to that and explore. But I think as Mr. Steen said, you know, just our general observations. We're looking at some applications on various sites, and you sort of look right. 18. It starts with 18. Presumably that does mean a 2018 application. You know, so yeah, we will return to this theme tomorrow morning, I think, as well.
Yeah, I just asked for sort of a bit of background just to understand, and it was precisely for that reason that you look at beginning numbers on the planning application, and it looks like it's been in process for a very long period of time. And if you've been working on it, then does that matter? Possibly not. But it just seemed to happen a fair bit, so probably worth just us being aware of why that was happening. So thank you, that's helpful. Yeah, I don't think I have anything else I particularly want to ask, in which case it will break for lunch, and we're due back at 2, isn't it? And I understand that we need to have finished by 4.
Yes, thank you, sir. That is correct. Yeah, we have a corporate scrutiny meeting in here tonight, which is dealing with the issue of school closures. So we do need to be out by 4 o'clock. And for those who are attending this afternoon, I'll perhaps just make a little mention of what some of the things might be occurring elsewhere in the building, just so people are aware. So
I think we've got quite a different group of people this afternoon, so there's nothing we can do to change the time we start or anything like that. So we'll see how we get on. We have had someone who would like to come, but can't for whatever reason. So, but we know what their interest is. So it may be that we, and maybe you'll help us with this, skip around the agenda a bit so that we leave if they're interested in to last. So if we don't have time to deal with them, then we can maybe come back to them on Thursday when they might be able to make it. So yeah, that I think was what we were thinking. So yeah, so we finish this session and we'll meet back here at 2 o'clock. Thank you.
thank you, sir. Thank you.